So, very good evening, my dear friends. Today we are going to discuss the last part of the subject of prospectus. And today we are going to discuss the effect of misstatement in the prospectus and rule of golden legacy. This is a very important subject matter for us. In brief, in fact, threshold, I have to tell you that, as I told you yesterday also, the prospectus should contain all the important details as required under the SEBI regulations today. That is the present law. And then we have discussed about this under section 26 of the Companies Act 2013 yesterday. And then in the event any of the promoters or directors make a misstatement, make a misleading statement, or a fraudulent statement with an intent to commit fraud on the incumbent applicants, then it will be dealt with very severely and it will entail civil and criminal liability on the appropriate persons who have committed that particular blunder. In fact, this is viewed very severely, I told you yesterday. And then this is called the rule of golden legacy. Basically, if you go to section 2, subsection 69 of the Companies Act, in fact, it deals with very clearly, I have already told you also, with regard to the promoters, where in that the relevancy is the word promoter means a person who has been named as such in prospectus. This is the most important aspect. Or is identified by the company in the annual return. We are not concerned with that. Then who has control over the affairs of the company directly or indirectly, and or in accordance with whose advice, directions, instructions the board of directors of the company is accustomed to act. And then, of course, exemption is for a person who is acting in a professional capacity. Then, friends, I have told you sections 23 to 42 of the Companies Act contain the necessary provisions on prospectus and allotment. And then both for private and public limited companies, private placement is concerned, section 42 contains the necessary provisions. Now, friends, we are on the particular third bit of discussion, which is called the doctrine of golden rule of legacy. What is it? Now, earlier it was section 62 of the Companies Act 2000, in fact 1956, contained provisions, whereas here it is only a reference to person as promoter. But what is important here is that rule of golden legacy. Every person, whoever is connected with issuing the prospectus, whether as a promoter or a director, authorized himself to be named in and is named in the prospectus, either in the capacity as a director or agreed to become a director, or immediately or after an interval of time, every person who is promoter of the company and who has authorized the issue of the prospectus is liable to pay compensation to every person who subscribes for any shares or debentures on the faith of the prospectus and then sustained any loss. Because an untrue statement has been made in the prospectus. This is the most important aspect. That is also otherwise termed as misstatement. So, what is this untrue statement? Basically, the law requires that the prospectus should contain full, frank, and honest disclosure of all the information with absolute accuracy. And if any material fact is withheld or any particular statement is made which is fatal to the contract, and with an intent to defraud the subscribers, then such particular person will be held liable both on civil as well as criminal liability. Friends, this is technically called the golden rule, not golden rule of legacy. This is called golden rule. And as to forming of prospectus, which was laid down in an important English case of New, N-E-W, New Brunswick, B-R-U-N-S-W-I-C-K, Brunswick, and Canada Railway and Land Company versus Muggeridge. New Brunswick and Canada Railway and Land Company. New Brunswick and Canada Railway and Land Company versus Muggeridge. This was a judgment of the Chancery Division given in 1860. This is called technically golden rule. What the golden rule says, this particular prospectus must contain the necessary details as contemplated under law. Now, which is the law? The law as laid by the SEBI. And in the SEBI website, you will find the relevant regulations thereon. And then these particular compliances ultimately must be given, and if any such report or any such statement proves to be untrue, misleading, or done with an intent to commit fraud on the subscribers, and the subscribers suffered a loss or damage, then they can sue the company as well as the promoters, and the promoters would be personally liable, both civilly and then criminally, to the affected persons. This particular rule, in fact, of this is which is called golden rule. This golden rule was changed as golden rule of legacy. Rule of golden legacy, otherwise rule of golden legacy by Justice Pagewood. Justice Pagewood in Henderson versus Lacon. Henderson versus Lacon. Actually, you must remember, in the original case, it was in the year 1860, the Chancery Division in New Brunswick and Canada Railway and Land Company versus Muggeridge described it as golden rule, and in 1867, the same Chancery Division subsequently by Justice Pagewood described this rule as rule of golden legacy. In the examination point of view, they will ask you, then you have to say the rule of golden legacy was brought into force by Justice Pagewood in Henderson versus Lacon. Muggeridge case is concerned, that is the actually golden rule, but not rule of golden legacy. So what is this particular change? The change says any misstatement is a statement made by the directors or such persons connected with the, in fact, particular issue of prospectus, which is made without bona fides. It could be an expert report also. It could be a director's report. It could be a statement by the promoter. But it was done without bona fides. The statement may speak about a particular thing in existence, but in reality, it is not in existence. So it is made with an intent to defraud the investors. And if it is proved to be a misstatement made intentionally, then the persons would attract civil and criminal liability. This is the most important aspect. Then in that event, what is the civil and criminal liability? Section 34 of the Companies Act 2013 deals with criminal liability. Section 34 says, criminal liability for misstatement in prospectus. Where a prospectus is issued, circulated, or distributed under this chapter includes any statement which is untrue or misleading in form or context in which it is included, or where any inclusion or omission of any matter is likely to mislead, even likely to mislead, not necessary to mislead, likely to mislead. Every person who authorizes the issue of such prospectus shall be liable for appropriate punishment as contemplated under section 447 of the Companies Act 2013. 447. Provided that nothing in this section shall apply to a person if he proves that such statement or omission was immaterial, that means not connected to the subject matter, or that he has reasonable ground to believe and did up to the time of issue prospectus continues to believe that the statement was true or the inclusion or omission was necessary. That means he must prove that he had no intent to defraud the investors. This is the most important aspect. Now we will come to the criminal side, civil side, where the civil liability for misstatement is concerned. It is multifold. Section 35 of the Companies Act 2013 deals with the civil liability. And the liability is concerned. Here it is multifold, where primarily it says that whoever is a director, a promoter, anybody authorized or an expert, they will all be liable under section 36. If it is proved that fraudulently they are inducing persons to invest money. But if a person is exempted, provided if a person proves that he gave a consent to become a director, but he withdrew his consent, or the prospectus was issued without his knowledge, or the statement purport to be made contained is what purports to be copy of an extract from a reported valuation, and there is no intent to cheat. In that event, he can escape. They are called gateways. Friends, section 36 says punishment for fraudulently inducing person to invest money entails a punishment under section 447 of the Act. Here, with regard to this defrauding, any agreement which has been entered with that, or with a view to obtaining credit facilities of bank, or any agreement, the purpose of the pretended purpose, which is to secure a profit to any of the parties from the yield of securities, these are all the things which would ultimately entail punishment under 447. Civil liability is concerned, again it will go to 447, 36, criminal liability also 447. Apart from that, under civil liability, the persons under section 35 subsection 1 would be liable to pay compensation to every person who has sustained any loss or damage. Then the affected persons could take an action, file a suit under section 37, that either by group or individually. And further, section 38 says any kind of personation for acquisition, etc. of securities takes place in this regard, he would be again punished under section 447 of the Act. So, now we have to go to 447. What section 447 says? This aspect I covered when we were dealing with promoters. I hope now you remember that. And then 447 is a residue provision. In fact, it says, number 1, punishment for fraud. It says that without prejudice to any liability, including repayment of any debt under this Act, that means irrespective of civil liability. Okay, any person who is found to be guilty of fraud involving an amount of at least 10 lakh rupees or 1% of the turnover of the company, this is the figure that has been given, whichever is lower shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 10 years, and shall also be liable to fine which shall not be less than the amount involved in the fraud, but which may extend to 3 times the amount involved in the fraud. This is colossal. One has to be, that's the reason why, extremely careful over these particular things. And then provided where the fraud in question involves public interest, the term of imprisonment shall not be less than 3 years, minimum 3 years, not 6 months. And then where the fraud involves an amount less than 10 lakh rupees or 1% of the turnover of the company, whichever is lower, and does not involve public interest, then any person guilty of such fraud shall be punishable with imprisonment for a term which may extend to 5 years, or with fine which may extend to rupees 20 lakhs, or with both. So here fraud means in relation to affairs of a company, any body corporate, includes any act, which the act means a particular action which is not supposed to be taken place but has taken place. Omission means which is supposed to be taken place but did not take place. Concealment of any fact or abuse of position committed by any person or any other person with a connivance in any manner, with intent to deceive, to gain undue advantage from, or to injure the interest of the company or its shareholders or its creditors or any other person, whether or not there is any wrongful gain or wrongful loss. Action is very important. Actus reus. Wrongful gain here means by unlawful means of property, a gain. Wrongful loss means loss by unlawful means of property, which the person losing is legally entitled. Then friends, punishment for false statement is given under section 448. Where any false statement is proved, report, certificate, financial statement, prospectus, any document, then which is proved to be false, punishment is as given under section 447. Same is the case with regard to punishment for false evidence. It is under 449, but the punishment is with an imprisonment of a term which shall not be less than 3 years, but which may extend to 7 years, or fine which may extend to 10 lakh rupees. Where specific penalty, in fact, or no specific penalty or punishment is provided in the Act, Companies Act, this is section 450, general provision. If a company or any other officer found contravening any of this particular law, where no specific provision is provided elsewhere, he will be punishable with fine which may extend to 10,000 rupees. And where the contravention is continuing one, with a further fine which may extend to 1,000 rupees for every day after the first during which the contravention continues. Then friends, section 457 is for punishment in case of repeated default. That is, it would be with twice the amount of fine with the offence in addition to any imprisonment provided for that offence. And 452 section, punishment for wrongful withholding of the property. Now friends, the central government, in fact, would appoint an officer not below the rank of Register of Companies to adjudicate upon these matters and then award appropriate punishment. So now you find there is a civil and criminal liability, and then the civil and criminal liability is concerned how it would be taken place. First, if it is a civil liability, then there would be damages, as I have already discussed that, section 35. And then compensation. The aggrieved person can claim compensation against the directors, against the company also. Then friends, what are the defenses? I have already told you. Defenses are also given. I have already explained just now. That the director contends that he has withdrawn the consent or absence of contract, ignorance of untrue statement, reasonable ground for believing the misstatement is true. This is what I just now read over. In this case, the most important citation is Derry versus Peak. Derry, Derry versus Peak, Peak. This is 1889 appeal cases, English cases. In this case, a tramway company's directors issued a prospectus containing a statement that by the special act the company had got the right to run its trams by steam power instead of being drawn by horses. The company had the authority to use steam power with the permission of the authorities in the Articles of Association and Memorandum of Association. Then, one shareholder took the shares in the company on the faith of the statement given in the prospectus. Unfortunately, the authorities refused to give permission and the company was to be wound up. Now the shareholder sued the directors, alleging fraud and claiming damages. Then the directors proved that they had the necessary ground to believe that statement is true and there is no ground to reject. Unfortunately, it was rejected, so that is beyond their control. Then it was held that the directors were not liable as they honestly believed that the statement given by them in the prospectus to be true, since the company had the authority to run trams, by steam power, in fact, instead of horses, subject to granting of permission by the authorities, and they never expected that such a catastrophe would take place and permission would be refused. But unfortunately here the permission was refused, so that is an exigency and business exigency rather, and there is no intention to cheat. Henceforth, there is no question of here giving them any punishment or fastening them with any civil liability also. So friends, if you look at this particular grounds, Derry versus P, Section 35 subsection 2 is relevant. Section 34 deals with criminal liability for misstatement in prospectus directly. Other provisions I read over are residue. Section 35 is civil liability where compensation and damages could be, in fact, thereof. The company and every person would be liable, who would be a director, who would be a promoter or so. However, the most important thing is that no person would be liable under Section 35 subsection 2, as I already read over, that having consent become a director, he withdrew his consent, or the prospectus was issued without his knowledge or consent, and as regards every misleading statement purported to be made by an expert, then in fact it was correct and fair, and then in fact there is no intent to cheat. And then further, most important thing here is that the provision says that the statement purported to be a copy or extract so and so, it was correct and fair statement, and a correct copy of or a fair extract from the evaluation has been given, and he had reasonable ground to believe and did up to the time of the issue of the prospectus believe that the person making the statement was competent to make it, and that the said person had given the consent required by subsection 5 of section 26, we have already seen, to the issue of the prospectus, and had not withdrawn the consent before delivery of copy of the prospectus for registration, or the defendant's knowledge before allotment thereunder. This is the most important subject matter, my dear friends. And then further, in fact, subsection 3 says, where it is proved that a prospectus has been issued with intent to defraud the applicants, then every person referred to in subsection 1, directors, promoters, experts, etc., would be personally liable, responsible, without any limitation of liability for all or any of the losses or damage that may have been incurred by any person who subscribed to the securities on the basis of such prospectus. So this is the most important factor, my dear friends. And then what you understand is they have got the ground to believe. This is the most important thing. And they believed. And then the consent was not withdrawn. So this particular, in fact, provision would not apply if it is proved. That is where Derry versus P comes into picture. And then with regard to this particular prospectus where the delivery of a copy of the prospectus for registration under section 35, now the word the filing of copy was replaced. So it is only filing and then it's a formality. The stringency was removed, and in section 26 of the act also the word registration has been removed and replaced with filing. Then under section 29 also the subsection, in fact 1 clause B, the word public shall be omitted. So you have to see the amended act where section 26, 29, 35 have been amended and they are relevant for our discussion thereon. So my dear friends, with this background, Derry versus Speak is a very relevant subject matter with regard to the fact that the persons making the statement in fact have believed that that particular statement was correct, and then they did believe up to the time of the issue of the prospectus that it is correct. So here also reasonable ground was found in Derry versus Speak. That's the reason why the directors were let off, saying that they are not liable in any way. So with this background, in fact, you can further supplement it with any latest case law. I have checked up yesterday. There is no latest case law here. Subsequently, these are all the relevant judgments, in fact, which are essentially to be taken with regard to rule of a golden legacy. And then you have to necessarily see the Magritte case and then Henderson versus Lacon's case. Today, rule of golden legacy is concerned, it is Henderson versus Lacon ultimately stands good, which is having a world phenomenon, and all over the globe this has been recognized. So with this, we conclude our discussion on this particular subject matter of rule of golden legacy in prospectus. So my dear friends, with this we conclude our discussion on prospectus. Definitely 20 marks question can come and you have to get well prepared and then do the needful thereon. So with this background, we'll proceed further, and then in our coming classes, we'll deal with other aspects of this particular, share capital, and then see slowly. Maybe tomorrow is a holiday for us, then we'll meet again on Monday. Thank you very much. Good day. Bye bye.
Thank you, sir.
Thank you.